Thank you for joining us for today's webinar. This is the 2025 In-House Counsel CLE series presented by Denton's US LLP. Before we get started, I have a few housekeeping notes. First, for the benefit of all the participants, attendees should have your lines muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space. If we cannot address your question during today's webinar, we will follow up after the program. Second, please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note that Denton's can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or a laptop device. Credit is not available for joining via a mobile device. Last, one other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the question and answer section of the screen. If you don't have a license in those states, you can disregard this. And so I'd like to, on behalf of my partner, Tanya Moyran, my name is Sam Maisel, I'd like to welcome you to the first hour of today's CLE. We're going to talk about dealing with distress in the healthcare industry in the new administration. And I seem to have lost, there it is. So I'll give quick introductions. My name is Sam Maisel. I'm a partner in the Los Angeles office of Denton's, and I help direct the firm's distressed healthcare activities nationwide. Tanya, do you want to introduce yourself?
Sure. Thank you, everybody, for the opportunity to speak with you today. My name is Tanya Moyran. As Sam mentioned, I chair our restructuring group. I sit in Los Angeles, but both of us really practice across the globe. And today we hope to chat with you, as Sam mentioned, about healthcare distress. And although the title says in this administration, a lot of what we're going to talk about today is really distress in the healthcare sector that has been here for decades, and prior administration and future administrations and so forth. So thank you again for the opportunity.
So look, we looked at the attendee list prior to the presentation. We note that a lot of you are not in the healthcare industry, so we thought we'd explain to you, why should you care about this as an issue? Well, besides the fact that everybody in America has interest in the healthcare system because we all access it at some point, and because it represents almost 20% of the gross domestic product. America spends a tremendous amount of money on healthcare. And as you know, a tremendous amount of political interest, local interest, it's all involved in healthcare. We're going to talk primarily today about some of the financial, Tanya's going to talk to you about some of the financial stressors that are particularly acute. But one of the reasons you should care about the issues we're going to talk about is because the Medicare and Medicaid programs are the largest payers of healthcare in America. They provide, almost half of the healthcare spend in America, which is trillions of dollars, is paid for by either Medicare, which I think most of you will probably know is federal health insurance, primarily for the elderly, and Medicaid, which is a joint state and federal program, primarily for the poor, just, in its simplest terms. Those issues, whatever happens in our Medicare, Medicaid programs, and in this administration, they are the subject of scrutiny, whether there's waste, fraud, and abuse in them, what are potential cuts in the payments. All these have really been highlighted in the last 3 months by the new administration. So we're going to talk about the legal issues that might arise for financially distressed entities because of Medicare and Medicaid revisions. The The other thing that we're going to talk about today is the impact on not-for-profit hospitals and some of the rules concerning not-for-profits. And that's because despite what you read about the impact of private equity in the healthcare system, most hospitals in America, for example, are still not-for-profit hospitals. And so any changes in the not-for-profit rules, and those hospitals, not-for-profit hospitals, are heavily dependent on Medicare and Medicaid. So again, impact of changes in how reimbursement occurs in either of those systems is going to have a huge impact on the financial viability of the healthcare systems in America. And with that, I'm going to turn it over to my partner, Tanya, who's going to talk about, why the healthcare system is facing financial distress.
Thanks, Sam. So as Sam said, one of the things that we want to talk about and that we consider is what are the key drivers and why are so many healthcare entities, including hospitals, in financial distress? So what happens in terms of what Sam and I do, and some of our partners like Sam Alberts in Washington, D.C. also do healthcare, is that a hospital will come to us or different types of healthcare entities will come to us and they're in financial distress, right? And a lot of the reasons that they are in financial distress could vary, but there are some key drivers and you'll see them up on the screen. So as Sam mentioned, a lot of hospitals and healthcare entities, as you know, survive basically based on reimbursement rates from Medicare and Medicaid. And so they receive these reimbursements after they provide services to patients. What happens is that these reimbursement rates are low and they are not enough to cover the cost of care. So by the time a patient walks out, many times that cost of care isn't going to be covered by Medicare and Medicaid. And so there's already an issue there. On top of that, I know a lot of you have read headlines and have known that in the healthcare industry and in other industries, the cost of supply has increased. And as we think about what's happening with respect to this administration and potential tariff increases, we can predict that these supply costs are going to go up even more, right? So that's a stressor on healthcare systems. In addition to that, you also have probably seen, especially during the pandemic, headlines with respect to labor costs. So, for example, nurses, cost of nurses and paying traveling nurses for hospitals, that's gone up ×4. And so now think of a hospital that's dealing with low reimbursement rates, increased supply costs, and increased labor costs. And how do you pay for those increased costs, right? In a hospital system, different from other models, you can't necessarily pass on the cost as easily to customers, right? You can't necessarily do that because you're locked in, for example, into collective bargaining agreements. In addition to that, you have like long-term contracts or other fixed government rates that you can't change, or rates with the insurer that you can't change. So you have an exorbitant number of increased costs and money is coming in that aren't sufficient to cover those increased costs. So those are some of the major drivers. Another major driver, particularly in the last decade, that has been a complete stress on healthcare systems are increased cyber attacks and paying costs to ensure that data is protected, having to pay costs when there's been some sort of attack, right? And by way of example, 2024, we saw the most healthcare data breaches. We're talking about data breaches that affected more than 180 million people, right? And so trying to now manage those costs and trying to protect against some sort of attack just adds to all of these other costs that end up piling up. And so that's some of the key drivers and some of why we see more distress. You'll see on the screen, there's infrastructure costs. Think of a hospital that, for example, we'll talk about Verity Health today, that, has infrastructure cost over the span of decades that it hasn't been able to keep up. And at some point, that number becomes so exorbitant that, they have to figure out how to address that. Sam, anything you want to add in terms of what we see with distress and some of the drivers here that end up, hospitals need some sort of restructuring protection?
Yeah, I mean, one of the things I would say is I was at a program earlier this year where an economist was talking about the impact of tariffs and suggested that one of the industries that wouldn't be affected was healthcare. And that's because I think the economist was thinking, well, healthcare is local, right? It's created in a hospital, you see the doctor. But the truth is, the medical devices, the durable medical equipment that every hospital relies on, it could be as simple as bandages, or it could be as complicated as, your hip replacement, or my hip replacement, for example. Those items are generally manufactured overseas and they will be subject to tariffs. And those increased costs, as Tanya said, are going to be very difficult to deal with. And so, the idea that the healthcare industry is somehow going to be able to avoid the tariff charges is simply not true. The other thing is the increased labor costs. There is a shortage of nurses in America. As the baby boomers like me age, the shortage of nurses is expected to increase. Many of America's nurses historically have come from overseas. That's just the truth. And to the extent that we restrict immigration going forward for lots of reasons, that the ability to replace, to satisfy the need for nurses through immigration is going to be more difficult, and that's going to exacerbate the shortage. So look, we're going to cover these topics today. We're going to talk about issues that arise with regard to Medicare and Medicaid. We're going to talk about how, just, to put it bluntly, in an era of increased financial stress, how do healthcare entities deal with some of the issues when outside of bankruptcy, basically the government controls the balance of power. And as Tanya and I have said repeatedly, I mean, one of the advantages to bankruptcy is it does change the balance of power by reorienting. It changes how the issues get faced when, we'll use hospitals as an example today, when a hospital gets into a dispute with Medicare and Medicaid. So we're going to talk about all these issues: jurisdiction, how fast can you get in front of a judge to resolve an issue with Medicare, Medicaid? How do you transfer the Medicare and Medicaid provider agreements? What's the rights of the government to offset ongoing payments to pay itself on a debt? Attorney generals in states across the United States have increasing power over the sale of not-for-profits, including hospitals. As we said, most hospitals in America are still not-for-profits. The bankruptcy courts, we've seen the ability to alter the balance of power between the hospital and the attorney general. And then we're going to talk about some issues with regard to False Claims Act and also with loans, and particularly in the skilled nursing industry. And I don't know, Tanya, if you want to add anything to that.
Sure, I'll just synthesize, which is outside of bankruptcy, most healthcare entities have little to no power when it comes to a dispute with the attorney general or governmental entities. Inside of bankruptcy, that balance shifts. And now you have a bankruptcy judge that is looking at all of the issues, and the healthcare entity has more power, whether it is to sell assets, transfer those human transfer contracts, and that's some of what we'll get into. And that's it, Sam. I just wanted to point out it's really that shift that's pretty major, and it gives these hospitals and other healthcare entities much more power inside of bankruptcy case than they otherwise would have.
Thanks. So one of the first issues is outside of bankruptcy. If you're a hospital and you have a dispute with the Medicare, Medicaid programs, the rules Medicare's rules say that you cannot get in front of a judge to get an impartial resolution of that dispute unless and until you exhaust administrative remedies that are set forth in the Medicare regulations and statutes. Those remedies can take literally years. For many years, there was a backlog. It's been addressed now, so it's not as bad as it was. But there were stretches where it was taking an estimate of 7 years to go through the administrative exhaustion of administrative remedies before you could get in front of a federal judge to try to resolve the dispute between you and Medicare if you're a hospital. It's a little better now, but it still averages 4 or 5 years. And during that period of time, if the government thinks they've overpaid you, they can start paying, they can offset the ongoing stream of payments for your treatment of Medicare patients to pay themselves the money they think they are owed. And then if you win, they would give it back. But in the meantime, the hospital is starved of income that it desperately needs to operate. So it's kind of like you can have your day in court, but you will be cash starved while you're waiting to get that day in court. And it obviously incentivizes hospitals to make settlements to resolve issues, maybe on terms that are less favorable than they think they should get, because they can't afford to operate with the cash flow reduction. In bankruptcy, the very important jurisdictions in America, very important courts in America, have held that the bankruptcy court uniquely does not have to wait for the hospital to exhaust administrative remedies before the court can take jurisdiction. This is an important change because if that's true, and in jurisdictions like California, Texas, Delaware, all important bankruptcy jurisdictions, the courts have held that they don't have to wait. The bankruptcy courts don't have to wait to take on resolving a Medicare dispute for the hospital to exhaust administrative remedies. So those courts, it allows a hospital in a dispute with Medicare to get in front of a judge more quickly before they're starved for cash and have to either go out of business or enter into a settlement which is less favorable than they would otherwise have. This alone is an important change and changes the balance of power because, outside of bankruptcy, having to wait for years to exhaust your administrative remedies literally forces settlements which would otherwise not be palatable to the hospital. So these are some of the cases for those of you who are lawyers out there. There's some case citations that talk about the third, fifth, and Ninth Circuit jurisdictions. There is one circuit court that is the 11th Circuit. So in terms of locations, think Florida, that have held that bankruptcy courts do have to wait. But again, the majority of courts have held you don't have to wait, and that's a huge advantage to healthcare providers. So I don't know, Tanya, if you want to add anything.
Sure, I'll just add that this is a game changer, right? Because not only outside of bankruptcy, as Sam said, would you be forced, a hospital be forced into an unfavorable settlement, but the hospital may also have to close its doors, right? So if you have to exhaust remedies for 5 years and you have very little cash on hand and you're operating in the red, you can't continue to keep the doors open. And so it is really important that you can go into a Chapter 11 case, get in front of a judge quickly and not spend years exhausting all of these different types of remedies. It makes all the difference in the world. And so doors at clinics and hospitals can stay open and continue to serve their communities by accessing this Chapter 11 path.
Yeah, and we saw the list of attendees again, and we know many of you are not bankruptcy lawyers. Let me explain to you why, getting in front of a bankruptcy judge can be advantageous. I mean, besides the fact that you finally have a neutral arbitrator, which you don't have to be I think, candid in the Medicare appellate process. In bankruptcy, you're going to have a federal judge who's, while they're going to call balls and strikes like every judge, but the point to the bankruptcy code and bankruptcy courts is to give companies a chance to get a fresh start, to restructure their obligations. So bankruptcy judges will look at federal lawyers representing Medicare or Medicaid, state lawyers representing Medicaid as another voice in what is effectively a three-dimensional game of chess, as opposed to the government coming into federal district court and having sort of the aura of being, representing the United States and having a little more clout than it would have in a bankruptcy court. So federal and state lawyers who represent Medicare and Medicaid, they are going to be much more hesitant to appear in bankruptcy courts representing their clients than they would than the federal district. The assistant U.S. attorneys, for example, would be in federal district court because they recognize that they're simply not going to get the deference from the bankruptcy judge that they would get from a district court judge. And so the idea that they're now going to be in bankruptcy court on short notice can be disconcerting. And it's also the speed in which bankruptcy courts resolve issues, right? Federal district courts will be much slower. Everything happens in bankruptcy court more quickly. And so this puts more pressure on the federal and state lawyers who are not used to having to proceed at the pace at which bankruptcy cases proceed. All of that shifts the balance of power to the hospital more than it would be certainly in federal district court if you had exhausted the administrative remedies. And I don't know, Tanya, if you want to add anything to that.
I think that covers it. Thank you, Sam.
Great. Okay, so as mentioned at the beginning of the webinar, we need to take a brief moment to satisfy your CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word shown on the screen, Medicare, into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it, and in case you don't see it on the screen, the code word is Medicare. And I'll give everybody a minute to do that. Obviously, if you don't have a license in those states, you can just disregard this.
Okay, let's hopefully everybody had a minute to do that. We're going to transition now to talking about selling and acquiring assets in bankruptcy. And so what you'll see on the screen is section 363 of the bankruptcy code. And that's a section of the bankruptcy code that we refer to as a tool because it allows you to sell assets in a bankruptcy case that are, free and clear of liens and most liabilities. So section 363 doesn't just apply in a healthcare case. So in case you're ever involved in any kind of bankruptcy case, whether it be a Chapter 11 reorganization or a Chapter 11 liquidation or a Chapter 7 liquidation or even a Chapter 13, you're going to be thinking about section 363 of the bankruptcy code. One of the most important obligations of a company in bankruptcy, of an individual in bankruptcy, is to maximize value for creditors. So you might think, how do you do that? Well, one of the ways you do that is you sell assets and you cut off certain liens and interest and liabilities. And that's really important because outside of bankruptcy, you can't do that, right? Like you can sell assets, but most buyers are going to buy them and they also are going to have to assume the liabilities, and that can be extraordinarily expensive. And it means that many times companies aren't going to be able to sell their assets, right? And so if you think about it in the context of a hospital, for example, in Chapter 11, Now, by being in a Chapter 11 case and by utilizing Section 363 of the Bankruptcy Code, you're going to be able to sell your assets, and buyers are going to be able to look at your assets and your liabilities. And buyers are going to say, you know what? These assets I think are valuable and I want to buy them. And these other types of burdensome contracts, they're not market. They're just a liability I don't want. And the buyer doesn't have to take it. So think of all of a sudden a buyer gets to pick the best assets and take them and leave behind all of these other assets that they consider to be more of a liability, right? And then those liabilities stay with the estate. So all of a sudden, if you have a hospital that isn't generating any profit, you can have a buyer that can figure out how to buy the assets and how to start operating that hospital at more of an asset, more of a profit, because they can leave behind collective, burdensome contracts, for example. And so what we've done in healthcare cases is utilize 363 to sell assets and to cut off liabilities. And one of the most important things that comes up in hospital sales are the provider agreements. And are the provider agreements that are needed to operate a hospital contracts that need to be assumed or signed? Or are they more akin to licenses that can be sold under 363? That makes a tremendous difference, because if they can be sold, these provider agreements under 363, you don't have to pay certain costs associated with them that we refer to as cure costs. And Sam's going to get into that in a more granular way, but I just want to make sure everybody that's listening knows this part of the bankruptcy code, it's about selling assets in any type of bankruptcy case, and a buyer being able to leave behind, liabilities with the estate, which is really important. So with that, I think the next slide, Sam, would be great.
Yep. So, just to follow up on one thing that Tanya was talking about is the ability to sell assets under 363 makes a significant difference in like a sale of a hospital. So Tanya and I have sold 9 or 10 hospitals in the last few years. And outside of bankruptcy, the due diligence that a buyer must conduct to buy a hospital can take months, sometimes years, because they have to examine, there may be years of unaudited Medicare, Medicaid cost reports. There's significant obligations back and forth between health plans. There's the False Claims Act is a huge issue. The Federal False Claims Act and many states, including California, where Tanya and I are located, have their own state False Claims Act. And, if you follow the news, there is a perception that the healthcare industry is just rife with fraud, waste, and abuse. And under the False Claims Act recoveries, the Department of Justice does an annual announcement at the beginning of a new year about how much it's recovered in False Claims Act recoveries. In every year since they've started making this announcement, the majority of the recoveries have come in the healthcare industry for lots of reasons, some good, some I don't agree with. But the requirements, these risks, Medicare, Medicaid overpayments, fraud liabilities, just garden variety overpayments between health plans. The due diligence required is monumental. And so the ability to sell a hospital with sort of lightening the load of the due diligence, because you can sell it to the buyer and cut off those liabilities. So the buyer doesn't have to spend months trying to figure out what the potential liabilities are and then adjust its purchase price accordingly. The ability in bankruptcy to sell them without successor liability really increases the value to the seller, but also increases the value to the buyer because it provides some certainty as to what they're buying. They're not buying some unknown liability that may take years to even arise. So that's all really important, a really important value of Section 363. And you see it in the hospitals Tanya and I have sold, which, we sell our hospitals in months from start to finish, where outside of bankruptcy, that would be unheard of. So one of the key issues, as Tanya mentioned, is the provider agreement between Medicare and Medicaid a license or a contract? So the Medicare agreement is basically a two-page agreement. It's not like any government contract you'll ever see, because it literally has the first section, the first half page says, welcome to the Medicare program. If you sign below, you have to follow the rules, statutes, and regulations. The second half says, don't commit fraud, and then you sign below. And that's literally the entire agreement. If you've ever seen a regular government contract, maybe in the Defense Department, they are delivered in multiple bankers boxes because they're huge. So it's completely different. The Medicare provider agreement doesn't look like a government contract. The state Medicaid provider agreements are frequently longer. California's version, for example, has about 40 numbered paragraphs. So it looks a little more like a government contract. What's interesting with both of these agreements is that for certainly the 30 plus years I've been working in this area, the government has always argued with virtual unlimited success outside of bankruptcy that the provider agreement is not a contract. And they do that because they don't want healthcare providers to have government contract remedies like access to the Court of Federal Claims. And courts have uniformly agreed that the provider agreements, Medicare and Medicaid, are not contracts between the hospital and the state or federal government. Interestingly, though, inside of bankruptcy, over the same period of time, the government has argued that these provider agreements are contracts. And they do so because, as Tanya said, they want the protections of Section 365 of the Bankruptcy Code, which says if the hospital here assumes the provider agreement under Section 365 of the Bankruptcy Code and then assigns it to a buyer as part of the sale transaction, the buyer has to take it with its obligations. And the hospital has to cure existing defaults, which means pay the money that's owed to the Medicare or Medicaid program. Obviously, both of these are huge hurdles in a sale transaction, particularly for a financially distressed hospital. So if you're not a bankruptcy lawyer, you might think, well, okay, maybe it could be a contract inside of bankruptcy and not a contract outside of bankruptcy. The problem with that is the bankruptcy code doesn't define what is a contract for bankruptcy code purposes. It adopts non-bankruptcy law. So and that is correct, if that's correct, then nothing about the filing of a bankruptcy should change the nature of a document. It shouldn't convert it from not a contract to a contract. So how has the government gotten away with this? Well, and they have, to be clear, gotten away with it because inside of bankruptcy, most bankruptcy courts to have addressed the issue have held that have treated the Medicare and Medicaid provider agreements as executory contracts and transferred them under Section 365 of the Bankruptcy Code. And this is because, just to be honest, it's a difficult issue, and and by the way, those rulings have occurred even in jurisdictions where the Circuit Court of Appeals, which controls the precedent for the jurisdiction, have held that the provider agreements are not contracts. We've seen bankruptcy courts not aware of those rulings rule that the provider agreements are contracts. And in most cases, the vast majority of cases, the issue isn't disputed. Sometimes because the lawyers are not aware of the controversy, but often because the healthcare providers are simply afraid of getting into a dispute with Medicare. And that's a business issue that Tanya and I grapple with all the time.
And I'll just add to that, obviously any hospital needs a provider agreement to be able to treat patients. And so this issue is one of the most important issues when you're selling healthcare entities. And to give you a real life example of what this boils down to, when we sold 6 hospitals in California, for example, in a case called Verity Health, if the provider agreement had been treated as an executory contract, we most likely would not have been able to sell the majority of the hospitals. Because what that meant is if the provider agreement was treated as an executory contract, there was going to have to be, let's just put in a number, $500,000 of cure cost that either the company or the buyer was going to have to pay. And certainly given all the liquidity challenges, the company couldn't pay that and the buyer wasn't willing to pay that. And so by treating the provider agreement as a license, it allowed Verity to sell these hospitals and not have to pay these exorbitant costs. Without that, it's possible, most likely, that Verity wouldn't have been able to sell these hospitals and they potentially could have closed. And I'll tell you, this issue is live and relevant in cases being filed today, right? And the government comes in like it does in Verity and makes the arguments that the provider agreements are executory contracts. And in Verity, we had to get the orders saying that they were executory contracts. I'm sorry, saying that they were licenses. At that point, then the government called and said, we want that decision vacated. Let's reach a settlement. And so you continue to see these issues come up today, in other cases. So I'll pause there.
Yeah, and one of the reasons this is important in the transfer of a hospital, sale of a hospital, is because you would think, well, why don't they just get a new provider agreement? Like, why would they want to take it with these risks outside of bankruptcy? Why don't they just apply for a new one? And the answer is Medicare makes it very difficult to get a new provider agreement without a huge gap, a significant gap in payment. So what Medicare has done, it obviously has a preference for the buyers to take on the seller's provider agreement, because then they have no gap in their ability to assert successor liability, right? They get paid throughout the process. If you say, okay, I don't want the seller's provider agreement because of the risks, I'll get a new provider agreement. You have to apply for the new provider agreement, continue to treat Medicare patients without reimbursement until you get an inspection. There's obviously an application, but there's also has to be an inspection of the facility, and Medicare puts the priority for inspection for new provider agreements at the bottom of the pile. So they have a limited number of inspectors. They're inspecting existing provider agreements and these new providers. And so there can be months of gap where you're expected to provide Medicare beneficiaries with care, but you will not be reimbursed for that care. So obviously the pressure's on to continue to take the provider agreements. Tanya mentioned the Verity case. So this case actually arose in the context of a Medicaid provider agreement, state provider agreement. But the state, interestingly, one of their primary arguments was to rely on all the cases where bankruptcy courts had treated the Medicare provider agreement as an executory contract. And they said, hey, we're just like the Medicare program. And the bankruptcy court noted that the Ninth Circuit, which controls its precedent, the bankruptcy court in Los Angeles noted that the Ninth Circuit had held in the context of a Medicare provider agreement that it was not an executory contract. And the California Supreme Court had ruled in the context of the Medicaid provider agreement that it was not an executory contract, not a contract, because that's the rulings that happen outside of bankruptcy. And Tanya and I, argued those cases to Judge Robles, the bankruptcy judge in Los Angeles. And so the court held that it was a license that we could transfer under Section 363, not having to transfer it as a contract under Section 365, and therefore we could cut off successor liability. a huge advantage to a bankruptcy transaction. Immediately after that, almost, the state called us up and said, we'll settle the transfer issue on terms, basically on the terms you've asked for, but you have to agree to vacate the opinion, which we went to Judge Robles and had the opinion vacated. And so we settled and avoided, potential years of appeal to get the resolution we needed for our client. But interestingly, the Medicare program also called and settled because they could see that the handwriting was on the wall for them. So the next issue we want to talk about, I'm sorry, Tanya, did you want to add anything?
No, I think we covered that. I think we can move on.
So the next issue, look, if there's an overpayment between a hospital and the government, either government, federal or state, the government normally outside of bankruptcy starts offsetting ongoing payments to pay itself monies that are owed. So you can write a check if the government declares an overpayment, or you can subject yourself to this offset, which is commonly referred to as recoupment. In bankruptcy, recoupment is kind of a wild card. It's not regulated by the bankruptcy code. It is, bankruptcy courts and higher courts, including the United States Supreme Court, have held that a creditor's right of recoupment survives in a bankruptcy and is not subject to the bankruptcy code. We can debate the value, the merits of that, but that's the settled law. This is an important issue in healthcare bankruptcies because that is how the government frequently recovers overpayments. So, the issue that had been litigated was whether this right of offset was a right of set-off, which is strictly controlled by the bankruptcy code, or a right of recoupment, which is basically not controlled by the bankruptcy code. And so, to cut to the chase on this, bankruptcy courts and circuit courts have generally held now that Medicare and Medicaid's right to offset ongoing fee-for-service payments, right? The payments they make for treating a Medicare beneficiary are a right of recoupment that isn't subject to the bankruptcy code. So filing a bankruptcy won't allow, in most jurisdictions, the ability to cut off the government's offset of an ongoing overpayment recovery. There is one important distinction in this, and that's in the Third Circuit, which includes the very important bankruptcy jurisdiction of Delaware. The Third Circuit has said that right of recoupment is more limited, that it only occurs if the overpayment that is being recovered occurred in the same cost report year. So think the same tax year as the ongoing stream of payments that are going to be offset. That's a huge difference because the government almost never can catch up with an overpayment that quickly. So that it's very unusual that an overpayment would be recovered from the same year as the ongoing stream of payments. They're almost always older overpayments.
Sam, to the extent that there's folks in the audience that haven't dealt with overpayments in the context of hospitals, can you just give a breakdown of how an overpayment occurs since we keep referring to overpayments?
Yeah, sure. Sorry. That's so look, there's a hospital submits electronic bills. So you go in, you get treated. The hospital submits an electronic bill, sheets of spreadsheets to the government, usually through a fiscal intermediary. So think Blue Cross Blue Shield, Palmetto, Noridian. There's lots of them nationally, and that intermediary will then do a review of the spreadsheets. Nowadays, that review is frequently conducted by an algorithm. And they will decide whether there's an overpayment or not, whether there's a valid right to be paid. And so they will then pay electronically to the hospital. At the end of every whatever the hospital's fiscal year is, the hospital has to submit a cost report, which think of it as like your annual tax submission to Medicare. That cost report is then audited. The government has 5 years to audit that cost report. And in the context of that audit, there may be an overpayment, there may be an underpayment discovered, and then the hospital will get what's called the notice of provider reimbursement that will tell the hospital, we think we overpaid you $100 5 years ago. Either write us a check or you can appeal, in which case we'll start recouping once the appeal is started, through the first, there's a couple phases where they can't recoup those first couple stages of the appellate process. So that's kind of how this works. But the other way you'll see an offset is if they believe there's been fraud. Same thing, they'll start recouping out of the stream of payments to pay themselves on what they believe was fraud. We're going to talk about one other remedy the government imposes. I hope that answered the question. So, it is important if you can file your bankruptcy case in Delaware, you can greatly limit the government's rights of recoupment. One of the issues we see now most often is not the litigation over this, whether this is a right of recoupment or set off, because that is pretty settled law now. But because Medicare and Medicaid don't cover the cost of care, as Tanya said earlier, they only pay, let's say 85% of the cost of care, which is why when you see articles about how Blue Cross and Blue Shield is paying so much more than Medicare or Medicaid for the same services, that's because those programs basically subsidize the Medicare and Medicaid program, which do not pay enough to cover the cost of care. Other things that states have done is created these supplemental payments. They're called state-directed payments. In California, they're called quality assurance fees. I mean, there's lots of different names, but basically what it amounts to is the state will impose a fee on a hospital. The formulas can be quite complicated, but let's say the hospital then will pay $1 to the Medicaid program. That Medicaid agency will recycle that dollar in a way that entitles it to federal matching funds and then pay it back to the hospitals. So the hospital pays $1, it gets matching federal funds and comes back as $3 to the hospitals to be spread according to another very complicated formula. What we've seen, the litigation now that we've seen is where state agencies are seeking to offset as recoupment those supplemental monies that are owed under those supplemental programs against the fee-for-service programs. And so that's, we've been able to stop that in cases, including Gardens Regional Variety, that's the regional hospital, that's a case of Tanya Nars, and also in the Seventh Circuit in a case called St. Catherine. We've been able to stop that and get the courts to declare that as set off, which, as I said earlier, is strictly controlled by the bankruptcy code, and the government can't impose a set off without bankruptcy court permission.
I think we could transition here, and in the interest of time, I think I'm gonna try to just hit on some of the key points, some of our last slides. And so we talked about Section 363, which is the section in the code that allows you to sell assets free and clear. Now what we're going to focus on is special rules for nonprofit healthcare entities. And so in a garden variety Chapter 11 case or Chapter 7 case, you sell your assets, you get a sell order that the bankruptcy judge gives you, and that's it. You get to go close your sale, and you usually don't see the bankruptcy judge again with respect to that sale. In nonprofit sales, it's different. And it's different because what the bankruptcy code section says is that you have to basically sell assets in accordance with non-bankruptcy law. And you're probably asking, like, what does that mean, right? And so in the bankruptcy code, we see 3 different sections that use different language to basically say that you have to comply with non-bankruptcy law. And that's because the Attorney General has the ability to supervise nonprofit sales. The litigation has been around, what does it really mean in terms of selling bankruptcy assets in accordance with non-bankruptcy law? In other words, how far do you have to really go? And does the bankruptcy code limit the Attorney General's powers? If you're the Attorney General or working for the Attorney General, your answer is no to that question. If you are the company in a hospital in bankruptcy, the answer is yes, right? And so what happens is when you sell assets for nonprofit, you get your sell order, but then after you get that order, you now have to comply with state law with respect to selling these assets. And so what we've done and how we've interpreted it is that that means you have to go to the Attorney General, submit thousands and thousands of pages in connection with the sale and answering various questions. And then the Attorney General either blesses your transaction with conditions, or doesn't bless the transaction at all. And if the Attorney General imposes conditions or doesn't bless the transaction, we've always said that you get to go back to the bankruptcy code, to the bankruptcy court, and you can ask the judge to cut off certain onerous conditions imposed by the Attorney General. You couldn't, for example, change the rules and all of a sudden sell a hospital to an entity that doesn't qualify, but you can cut off conditions. And so it's more complicated in a nonprofit case because there's really more steps. You've got to get your sell order, you've got to comply with non-bankruptcy law, and then you got to deal with, the ramifications of that. So I think in the interest of time, let's move on. So those are the bankruptcy code sections with respect to a nonprofit. Now what I'm going to transition to is just different considerations when you're selling nonprofit assets. So one of the most important things, and we touched on it, is maximizing value and companies having a fiduciary obligation to their creditors to maximize value. In a nonprofit, in addition to maximizing value, the nonprofit is thinking about their charitable mission and thinking about, how do I continue my charitable mission? And so when you're looking at buyers, you're not only looking at what's the highest and best offer, but you're also now looking at what entity is also going to continue this charitable mission. So there are hypotheticals we often get into. Sometimes it's become a reality where, what if the offer that continues the charitable mission is lower than, a different offer? Like, you have to balance it, right? Balance your fiduciary obligation to creditors to maximize value, and then also to continue the charitable mission. And we had a case, Borrego Healthcare, Southern California, where the board chose the lower bid because they did continue the charitable mission. In that case, either offer would have paid unsecured creditors in full because of the arrangement that we reached with the Department of Healthcare Services. But it's just an example of this balancing act and what comes up. And with that, I think, given the interest of time, we'll just switch to the next slide, which again touches on Verity Health. And I think we've talked a lot about Verity, but the punchline here is the Attorney General tried to impose conditions that were onerous. They would have translated to, in one of the sales, an additional $5 million that, the buyer wasn't willing to pay. So we had to go to the bankruptcy judge. And because those conditions were based on the historical operations of the hospital, we were able to cut them off and still sell the hospital and the assets. At the end of the day, what happened is, as soon as we got the order and the memorandum from the bankruptcy court, we received a call from the Attorney General's lawyers, and they wanted to reach an agreement, which of course involved vacating that decision. But you can see how it changed the balance of powers because now we reached a favorable settlement agreement. And with that, I will pause and see what you want to add, Sam. And I know we have another slide or two.
Yep, no, that was great. Thank you.
So the last issue we'll touch on really is important. And our clients that come to us often are in a situation where CMS or a unit of CMS has suspended their Medicare or Medicaid payments. And most of these entities survive on getting these payments, these reimbursements, right? Like, think of an entity that has revenue that, 80% of their revenue are these Medicare, Medicaid reimbursements. If those reimbursements are shut off and that money isn't going into their account, they can no longer pay employees, pay any other obligation, right? And outside of bankruptcy, to try to appeal a decision where their payments were suspended, it's going to take you years. Inside of bankruptcy, and this touches on what we talked about earlier, you can get in front of a bankruptcy judge and you can try to basically stop that suspension. And what happens inside of bankruptcy case, as soon as you file, the company gets a protection. It's the equivalent of an injunction. It's called an automatic stay. So when we've represented entities, we've had to prepare them for Chapter 11 and filed a complaint and basically said to the bankruptcy judge, the automatic stay protects this entity and basically requires the government to start paying these reimbursements and start depositing these monies into this account so this entity can survive. And again, this is a really important and valuable tool of the bankruptcy code, because now, for example, Borrego Health, I mentioned 16 clinics in Southern California providing services to underserved communities can keep their doors open. And the government was required to start reimbursing the clinics so they could continue patient care. And patient care was not interrupted by the use of a Chapter 11 and by bankruptcy orders entered by the bankruptcy judge. So with that, I'll turn it over to you, Sam.
Thanks. The last issue we do want to talk about is a recent case that Denton's litigated in the Midwest, and it resulted in a really important ruling. So outside of bankruptcy, HUD and the FHA are the 800-pound gorillas. So we've talked about Medicare, Medicaid. This is just another government agency we have to deal with, but they provide the bulk of lending into the skilled nursing industry, which is, there are thousands of skilled nursing facilities in America. And so the question that arose in this case from last year was, were we able to prime HUD's loans? So outside of bankruptcy, HUD takes the position that the National Housing Act means that you can't borrow money that would be in front of HUD's security interest. And obviously that's a problem if you need to borrow more money, as financially distressed entities frequently do, and HUD refuses to allow itself to be put in second position. So in this case from last September, Denton's was able to achieve a court ruling where it got debtor in possession financing in bankruptcy, was able to get a loan that primed HUD. And the bankruptcy court held that the bankruptcy code's provisions allowing debtor in possession financing preempted the National Housing Act's rule that it had to be, that HUD had to be in first place. So just another example of bankruptcy changing the balance of power from outside of bankruptcy. So in conclusion, I mean, I know we've covered a lot of ground. If you're not bankruptcy familiar or healthcare familiar or both, we've covered a lot of issues and topics that are going to be new to you. Both Tanya and I and our partners across the country are obviously happy to talk to anybody about any of these issues separately. And with that, I want to thank you again for participating in this first hour of today's CLE webinar. I will now turn the program over to Dan Schnapp, who is a partner in Denton's intellectual property and technology practice, for the second hour.
Thank you very much, Sam, and good afternoon, everybody, and good morning to our friends on the West Coast. We're excited to bring you today a presentation regarding trade secrets. And the title of our program is Trade Secrets Are a Company's Most Valuable Assets, a Guide to How to Protect Them. And before we get into the material itself, I want to give a special thank you to our colleagues, Michael Franzinger and Tony Liu, who will also be presenting with us today. Michael is a partner in our Washington, D.C. and Los Angeles office. He's a member of our Intellectual Property and Technology Group. He is an extremely seasoned litigator. He has a focus on Section 337 investigations before the ITC, as well as many notable cases in the federal court in all forms of intellectual property matters, including trade secrets. And our colleague Tony Liu joins us from our Boston office. And Tony is also a very experienced litigator in the area of trade secrets and intellectual property, as well as commercial litigation. He has broad experience handling all aspects of such litigation, including pre-suit investigations, and he will be a valuable asset to us, as well as he will be speaking extensively on some cases that he was personally involved with. So without further ado, let me move on and let me ask that we go to the next slide, please, Brian. Here are your presenters. That's me on the right. I'm a partner in our New York office in the intellectual property group, and I have been practicing litigation in both IP and commercial for approximately 25 years. Let's go to the next slide, please. So this is going to be the agenda for our course today. First, we're going to go through best practices and strategies for protecting and enforcing trade secrets, and I will be speaking largely from the perspective of employment law and bringing employees on and then exiting them and making sure that companies do what they need to do to protect not only their trade secrets, but from inadvertently bringing trade secrets of third parties into their company. We'll then discuss a very hot topic, which is trade secrets and artificial intelligence. We'll go on to talk about how to prevent the loss of trade secrets in corporate transactions. We'll discuss another hot topic, which is how trade secrets relate to government contracts and regulations. We'll conclude, and then we'll leave a little time at the end, hopefully, for a Q&A. So let's go to the next slide, please. I'm going to be discussing first best practices. And as I said before, a lot of this has to do with best practices in bringing employees into a company. Next slide, please. I would say that, people, and that can mean employees, are often the vehicles by which trade secrets come into companies, they can leave companies, and therefore making sure that companies take appropriate safeguards to protect the loss of trade secrets through the departing employee or even a new employee coming in is really critical. So people means and can mean disclosure of trade secrets, and disclosure of trade secrets can mean the loss of trade secrets. And of course, the loss of trade secrets is really can lead to irreparable harm to a company's interests. Now, here we have Dan Schnapp's 3 Ps. That is a mnemonic device that is not intended to be a trademark, but just to think about hiring and onboarding employees from the perspective of preparation, process, and then protecting your secrets. So what does that mean? Let's go to the next slide. Preparation really means that even before an employee is brought into a company, that an employer has gone through the process using legal counsel, whether in-house or outside legal counsel, to prepare documents, that is the right documents, and to take the time to create the right documents, to make sure the policies and procedures are memorialized appropriately when it comes to how the company is going to treat both the employee coming in with the possibility of bringing in trade secrets from third parties, and then later how the employee might leave, whether it be through termination, and whether it be through resignation, however the employee leaves, to make sure that at that time, a trade secret is protected and not lost. And some of this is fairly common sense. So obviously you want to keep those policies and procedures updated constantly. I would just add here that oftentimes we're talking about employment agreements that include non-compete provisions, other kinds of confidentiality provisions, which we will discuss in more detail. But the payoff for creating the right documents and creating the right processes is always that down the line, should something happen, you're way ahead of the game because you've done your due diligence and you've created appropriate procedures from the beginning. Okay, let's go on to the next slide, please. So hiring and onboarding employees. So the first thing is that employees who come into a company may unwittingly be traveling with the intellectual property of their former employer. And sometimes it's not unwitting. But either way, it's important to put into writing in their employment agreements what exactly the obligations are. Obviously, it's very important that the company not inadvertently take on the trade secret or other intellectual property from another company and then get sued. So it's very important that there be a very explicit understanding between the onboarded employee and the company that the company is not accepting in any respect any trade secret or intellectual property that belongs to a third party. Similarly, the onboarding employee might not be aware of what IP they've been exposed to during prior employment, and there is a process by which you can educate that onboarding employee. You can define what a trade secret means, and we'll get into this a little bit later, but it probably is worth mentioning now that a trade secret can be one of a variety of things. It could range from being a formula, it could be a recipe, it can be a compilation of some kind. And it really, depending on the industry, a trade secret could really be one of many, many different things. So trying to nail down what the trade secret might be is very important. Similarly, as I say here, do not bring mud into the house. That is, it is one of the most effective ways of protecting a company is to make sure that whether or not an employee is actually traveling with a trade secret and bringing one to the company is ferreted out from the very beginning. That mud means the inadvertent disclosure or disclosure of a trade secret. So for example, if an employee comes onto a company and that employee has a flash drive from a prior company and that flash drive has information, proprietary information belonging to the former employer of that employee, that could pose a litigation risk and a risk of even injunctions and so forth to the new company. So it's also important that in onboarding employee and in that agreement, the employee should assign to the new company that that employee is working for all right, title, and interest in any inventions, original works of authorship, trade secrets, and other intellectual property developed while in the employ of the company. So the employment agreement should typically have specific provisions. It's essentially like a work for hire provision, but it's important that employment agreements have that information so that the employee cannot later claim that IP belonged to them. Let's go to the next slide, please. As I said before, drafting ironclad confidentiality provisions and making them a condition of employment are extremely important. And we'll talk throughout this presentation about confidentiality provisions. Really, they are the most straightforward, simplest, and frankly, cost-efficient way to protect trade secret status. It's also important that the company and its counsel regularly review and update the company policies regarding trade secrets. That is true not only for the common sense reason that it's the right thing to do and a best practice, but you'll also potentially down the road, if litigation ever should come up, need to show that you took all reasonable efforts to keep trade secrets of other parties outside of your company, and you took reasonable efforts to protect your own trade secrets. That is one of the most important things that a court or an arbitrator may look at. Did the company take reasonable efforts to protect its information? And another reason to update your policies is because the law, of course, always changes. An example is the Defend Trade Secrets Act, which we'll talk about a little bit later, which is the federal statute that applies to trade secrets, which was put into law in 2016, has certain whistleblower protections. It has other aspects of the law that may change over time. So it's just a good practice to always make sure that you're keeping track of what is changing in the law. Obviously, non-compete provisions have been the subject of Federal Trade Commission investigation. The different states have different views about how narrowly drawn non-compete provisions will be, and those may also apply to how trade secrets are treated. So always important to stay abreast of what is going on in the law. Also important to have personal device policies That is, what information is going to be stored on a company laptop, a company cell phone, or any other kind of company property. That personal device policy, of course, should always be in writing. And it's also important that you should treat your employees from the lowest to the highest generally the same. That is, don't simply assume that because somebody is at a lower level of the corporate hierarchy that they will not have similar access to trade secret information. Let's go to the next slide, please. And similarly, when an employee leaves a company, it's important to also exercise the 3 Ps: prepare, process, and protect. Let's go to the next slide, please. As you do when onboarding an employee, creating a process in writing is essential. And that process must remind employees about their legal obligations and terms of agreements that are still in effect when they are departing the company. Then verify what information the company had access to and ensure they return all company property, including documents, devices, and other company information. That's pretty straightforward. Let's go to the next slide. But I think where it gets a little less clear, Brian, let's go to the next slide, please, is when we are doing the process. So providing a copy of the most recent signed confidentiality agreement, of course, is important. But I believe that a company should not be shy about trying to get some important information about that employee's post-departure plans. Of course, you want to be sensitive to what the employment law is in the state. You want to make sure that you're not violating any rights of privacy. But to the extent that you can, finding, where is that person going to go? That can be important. You want to be able to, if it turns out that they're taking a trade secret with them, you want to be able to find them, which is also a reason why you want to take possession of their office keys, badges, company-owned devices. You want to disable passwords, pins, emails, anything else that would allow them to maintain access to company trade secret information upon their departure. Next slide, please. Some of this on this slide is probably a little more controversial, and it also may depend upon the company's resources, but there may be some, if it doesn't violate privacy laws or other laws, it may be worth it to track an employee's computer and telephone in real time to make sure they're not disseminating trade secrets upon their departure. They may be going to form a competing company. Obviously, that's something that you need to pay attention to. Their social media may provide clues and keys as to whether or not they're actually doing that. And obviously, once you acquire the departing employee's hard drive, make a copy. You never know what might be on there. Okay, let's move on to the next slide. We'll talk about this a little more in detail, but I'm just going to repeat one more time that confidentiality and non-compete agreements are the most cost-effective and most straightforward way to preserve trade secrets and the loss thereof. And I think that in all instances, companies should have those written, they should be updated, and they should be constantly provided to employees, and they should be an integral part of a company's policies and procedures. Let's go to the next slide, please. So we'll get into this also in a little bit more detail, but just sort of as a taste. Obviously, we talked a little bit about non-disclosure and non-compete agreements and restricting dissemination of confidential information, but it's also worth noting that trade secrets don't always exist in an employee's files. They can exist on hard drives, computer equipment. They might be in hard copies. So it's also important to physically secure and establish procedures to prevent unauthorized access to buildings, equipment, computer equipment, and networks. Next slide, please. And use your IT folks, use outside consultants, figure out ways to establish security audit measures, follow them, restrict access to software source code, build multiple passwords. Again, courts and arbitration tribunals will look to see what measures did you take to protect your trade secrets. And if you don't take the most significant measures, you may not be able to claim trade secret protection. Lastly, go to the next slide, please. If the worst happens and trade secrets are in fact taken and you need to act, there's a variety of ways of doing it, starting from the top, cease and desist letters. I believe that cease and desist letters are typically part of the process to put a party on notice, especially if you're going to be seeking an injunction. But cease and desist letters simply don't have the force of law. They're not the same as a court order. And if a cease and desist letter is ineffective and it doesn't bring about the desired conclusion, then of course you can seek an injunction in state or federal court. You can, if there's an arbitration provision in the employee's agreement, you may be able to seek an injunction through an arbitration panel, such as the American Arbitration Association. Now, moving on, I'm going to bring my colleague, Mike Frenziger, in. And Mike, I want to ask you, I believe that one of the topics I highlighted in the beginning and probably warrants special attention today is artificial intelligence. And I know, Mike, you've done a lot of work in this area. So let me ask you at the outset, can you have a trade secret if you use artificial intelligence to come up with it?
Thanks, Dan. And yeah, the answer to that is yes, you can. And if we could skip up 2 slides, then I'll go into that a little bit. So it's actually less legally complicated to have a trade secret generated through the use of AI than it is in the case of other intellectual property like patents or copyrights. There's no need under the trade secret rules to have a human inventor or author managing or involved in the process. So it is definitely possible for AI to be used and to generate trade secrets from that. And it doesn't inherently undermine any of the protection that you're going to get. Now, there's some caveats to go with that. It's for your trade secret to be both enforceable and something that you can properly keep track of when you are doing the things that Dan recommended that you do in the previous section of this presentation. You have to understand and be able to identify what precisely is the trade secret that you're talking about. And as sometimes happens with AI, it's not always 100% clear the inner workings of what's going on with your system. And so there are some things, however, that you do know when using an AI tool. And here we're speaking mostly about large language models, which are the main flavor of the month in AI these days, the ChatGPTs and Claudes and Copilots and Geminis of the world and so forth. So, and with those, you're putting in an input prompt or series of them, and you're getting an output in the form of text or code or graphics or something like that. And both the prompts and the outputs could be trade secrets in the right circumstances, as long as they meet the normal trade secret requirements of being actually secret, being the subject of reasonable efforts to protect their secrecy, and having economic value due to their secrecy. So that points to one of the other caveats with having trade secrets in the AI context, and it's important to maintain confidentiality throughout the process of creation of that trade secret. So let's go to the next slide. With AI, there are many points along the road where there is a risk that something could get out or otherwise have its trade secret status undermined. And so there are things you need to know about what the particular AI tool that you're using is doing, how it works, how it's managed, what its policies are, and so forth. So an example of that is storing of the inputs. So some of the systems, depending on how they're set up, will store the inputs that the users put into it. And that could potentially be seen as a disclosure if you're inputting trade secret information into it to a third party. That is, the LLM provider will be getting and keeping a copy of what you put into it. Next question is, how does it use those inputs, especially if it's storing them? Will the system use what you type into it, what your employees type into it, for training? And could it therefore, in certain circumstances, if asked the right question, essentially spit out your what you hoped to be a trade secret to a competitor who's posing that question? And if it did that, would you even find out? Often not. So these are some of the risks that you want to manage against when developing policies and systems for managing your employees' use of AI. Next question, maybe a little bit more old school in terms of any use of third-party software, but does the AI tool have adequate data security? So if I would think that the larger AI providers would be pretty advanced in terms of their data security, but if somebody is using one that is maybe off the beaten path, or in other regards somehow doesn't really have adequate data security, that could either be a failure of reasonable efforts to protect the trade secrets, or could simply be just a situation where they get out, whether through misappropriation or not, and somebody discovers them and is able to start using them. Another instance where you want to be careful and know how your AI tools are set up and what their policies are is in the context of, and I mentioned this since we're on a Zoom call right now, if you have an automatic meeting recording or summarization function activated, that could be another route whereby the information that you may have discussed in that meeting that may include your company's trade secrets may be going to the wrong places or may be inadequately protected. Lastly, this is a little bit of a different aspect because it could apply even with regard to AIs that your company is not using. But many of them train the AI systems by data scraping, by grabbing things off the internet and using those to help the model develop correlations between different words and numbers and things like that. And so this is a problem that actually existed before AI in other contexts of data scraping like search, but you got to be careful with the things that could be gleaned from things your company puts on the internet, even if it's not humanly visible. So there could be metadata and things like that that should be, you should make sure that you're not inadvertently disclosing something that you don't want to disclose through that kind of behind the scenes, but still obtainable from the outside kind of material. So going on to the next slide, this is a somewhat infamous cautionary tale from a major electronics company where the employees, even though they weren't necessarily authorized to do so, were using just a public AI chatbot that's very commonly used. And the employees did three different things, different sets of employees did them. They put in some of the company's source code to check it for errors. They asked the AI tool to optimize some code they'd written. And just as I mentioned on the last slide, they had it record the minutes of a meeting where they were discussing confidential information. And these aren't necessarily going to be fatal to the trade secrets, but it certainly casts doubt, and the company was certainly worried about it, and they even, I think, allowed it to be publicized, at least within the company, as a cautionary tale. They cast doubt on two elements of the trade secret protection. One is that the secrets are not generally known to others, which they may have become known to at least the AI tool provider, if not to other users of that AI tool subsequently. And then also the reasonable efforts to protect the secrecy of the information. So, you know, even if the trade secrets didn't actually get out through the use of the AI, if someday they tried to enforce their protection over these trade secrets, they would face arguments from the defense that they had allowed the secrets to become generally known and they hadn't taken adequate efforts to protect their secrecy. So moving on to the next slide. Got tips and best practices for protecting trade secrets in this AI-oriented age. And the thing to bear in mind here all the time as a guiding principle is that your employees are most likely using AI more than you realize. And so this is why you really need to be up on not only the AI tools that your company has immediately adopted, but also how the other ones work, just in case people are using them without your complete knowledge. So each of the major AI tools is different, right? They have different blends, they strike different balances between privacy and adaptability, among other things. Some of them specifically say that they use your data to train the AI to work better, at least for your users. And even if that is done only within the company, like even if they've ring-fenced where your data is going, it might be going to the wrong place within the company. So you might have to have multiple layers of ring fencing that you work out in a specific deal with the provider. You might have restrictions that you give to your employees as to what kind of information can be put where and into which AI tools. And you may want to specify that, yes, they can use some tools that work a certain way and not others because they don't have enough protection. I will point out that even in the public versions these days, a number of the AI providers have different opt-out features where you can set them user by user. So it's important that every user complies with this if you're going to allow them to use the tool. To not use your data for training, to not store the data that you put into the prompts, and so on and so forth. So in addition to having the right settings, having the right rules, you want to give clear guidance to your employees on training and handling AI and confidential information, and also just on which material is a trade secret in the first place. I mean, this applies not only in the AI context, but in all contexts. You know, you want your employees to be reasonably aware of you know, what is a trade secret versus what has been, for example, put out to the world in the form of a published patent application, and therefore you don't need to worry about it on the trade secret side anymore. The next slide. So wrapping up this section, we've got a few miscellaneous emerging issues for trade secrets in the context of AI. And these are not so limited to just large language models, but to more general types of AI. And so one thing I would say is that AI, one of the things it's good at is recognizing patterns that humans might not detect and figuring out small details. That's why some AI systems were, for example, able to win strategy games, even against the best human players, and are able to figure out complicated things like protein folding. So this characteristic may equip AIs to be used in some instances for more effective reverse engineering than people can usually do themselves. And so reverse engineering is permissible. That's not misappropriation of a trade secret. And so therefore, trade secrets could become vulnerable to legal detection and unpacking by competitors through the use of AI. The kind of universality that we're getting toward with AI tools also might therefore make it easier for something to be reasonably ascertainable through proper means. Or in other words, conversely, set the bar higher for something to be a trade secret, which needs to be not reasonably ascertainable through proper means from public information. If everyone's got an AI, then you may have to have a higher level of protection to protect it from that kind of discovery. And then finally, we've heard a lot about agentic AI, that is AI agents that can accomplish some task or goal for you by interacting with other computers. And some experiments have caught agentic AIs engaging in what we might call bad behavior or unintended uses, such as hacking into games, or lying, or doing things like that. And so it is conceivable, I don't know of any actual instances in the real world yet, but that an AI agent given a certain goal and not adequately governed and restricted in how it operates might steal a trade secret by hacking or some other means. And in that case, the owner or controller, the person sending it on the task, may face responsibility for trade secret misappropriation that they weren't anticipating.
Thank you very much, Mike. And
if we could go to the next slide is a code slide, I believe.
oh, yep.
So as mentioned at the beginning of this webinar, we need to take a moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word protection into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is protection.
Thank you very much, Mike. So earlier in the presentation, I spoke a little bit about how the company can protect itself when it onboards employees or those employees or other employees leave the company. And we've discussed now a little bit about how AI may affect trade secrets in general, as well as how AI affects trade secrets in the workplace. But I think one of the interesting topics I'm going to ask our colleague Tony to speak about now is what happens in a corporate transaction. We're speaking in this case like a major corporate transaction, like a merger. You might have many employees living all at once. Tony, what do you do in that situation?
I think in that situation, you would follow the second P of your 3 Ps, Dan. That is follow the process, the same process that you would use to onboard new employees you would have to do with the employees that are coming into your company. But I'm actually going to talk about a slightly different situation here. That is, I wanted to talk about the additional risks for trade secret misappropriation in an instance, for example, where you as a company are trying to get a deal and you are voluntarily providing confidential and trade secret information, typically under an NDA, to get a deal. So I'm here to talk about some of the best practices to help protect trade secrets under this scenario. I'm sorry, can you go to the next 2 slides, please? Oh, next one. And next one. Now, just as a general background matter, it's not so secret that trade secret cases can be expensive and time-consuming because things are very fact-specific. Whether a trade secret is a trade secret and whether a trade secret was misappropriated are highly fact-intensive and expensive to prove. The goal here really is to reduce the risk of trade secret litigation to the extent possible. And if necessary, you can better prepare to seek legal recourse in the event you discover trade secret misappropriation. Next slide, please. Now, when I mentioned the typical scenario that I wanted to talk about, these are the types of situations where you're voluntarily transferring trade secret information to another party, typically under an NDA. Sometimes the deal works out and you end up in a merger situation. Sometimes the deal doesn't work out and the parties go their separate ways. And that therein lies some of the risks with trade secret misappropriation. Next slide, please. And if you don't think that can happen, well, here are just some real world examples from the last few years where such a scenario has risen. Now, the first case there, Propels Fuels versus Philips, was a proposed acquisition where a larger entity sought to acquire a smaller entity who had developed a very specific technology related to renewable diesel fuel. An NDA was signed, information was exchanged, but then at the last minute, the larger entity pulled out of the deal and then developed their own competing business. And that resulted in a trade secret trial and a fairly substantial verdict for the plaintiff. The next case out of Washington, the Zunum case, was an investment deal where Boeing invested in an electrical airplane startup. Again, trade secrets were shared, and it was alleged that Boeing took the trade secrets to start their own division for electric airplanes. Another case out of Wisconsin was a joint venture, a failed joint venture, where one of the parties to the joint venture essentially cut the other party out of the deal and tried to use information acquired during negotiations to develop and market micro hospitals. And then the next case out of Michigan is the Ford case. It was a long-term licensing deal where after, I think it was about a decade worth of a licensing deal, Ford ended up developing competing software and cut out the licensor. And again, that resulted in a substantial jury verdict as well. And then the last example that I'm showing you here on the slide is out of New York. It was a potential partnership where two parties agreed to invest in certain companies. Again, confidential and trade secret information was shared, and then one party cut out the other party and used that information to bid up acquisitions, thereby driving up the price. So these things do happen. Next slide, please. Now, Dan touched a little bit on the trade secret definition, and I just wanted to emphasize that as a general matter, before contemplating a deal or beginning a negotiation, it's important to conduct an internal trade secret assessment. Now, the assessment helps to reduce the ambiguity, it helps to know what the valuable parts of the trade secret are, and it helps to know what you're protecting, what you should be protecting, and also how to go about protecting it. Now, on the screen there is a sort of a cribbed version of the definition of a trade secret under the Defend Trade Secret Act. As you can see, it's a very broad definition, any financial, business, technical, or economic information that's tangible or intangible. Now, the kicker is that there must be reasonable measures to keep that information secret, and the information must derive some economic value from its secrecy. So that definition can cover many things. Next slide, please. We can use a widget as an example. The technology for the widget is an obvious one for a claimed trade secret, but you must also define what aspects of the widget technology that no one else uses. That is secret and separate from what is generally known. Now, there's some lesser known trade secrets. For example, your marketing department may have developed a customer list or customer preferences for the widget. That information can be considered a trade secret. Likewise, your pricing and marketing data can also be considered a trade secret. In some cases, even your training manuals on how to sell the widget could be considered a trade secret if it meets the statutory definition. In one case that I was involved in, keywords associated with Google Ads was considered a trade secret because it was a compilation and the information derived economic value because it contained a lot of sales and data conversion information. And just to share one of my favorite examples of trade secrets out there based on creative lawyering, the owners of the Wu-Tang Clan Once Upon a Time music album, and there was claimed that as a trade secret because there's only one physical copy of the album in the world, and the Wu-Tang Clan specifically required the owners to sign a contract prohibiting widespread dissemination of the songs. So next slide, please. And in the interest of time, I'll run through this very quickly. Trade secrets do need to be defined with reasonable particularity. As I mentioned, it has to be, you have to distinguish between what is generally known and what is secret. And this is important because in some jurisdictions, such as California, you need to define your trade secret with reasonable particularity to proceed with litigation. In the Zunum case that I mentioned earlier, they actually had a jury verdict that was overturned. It was an 8-figure jury verdict overturned because the judge ultimately found that the trade secret was not defined with particularity. Next slide, please. Now, in terms of best practices in connection with protecting trade secrets during the deal, as I mentioned, very important to conduct a trade secret assessment beforehand. It's important to label everything with confidentiality clauses, and Dan touched upon this as well, set up proper security measures such as password protection, encryption. And this is helpful, especially with the assessment, because with the NDA, that is a must. It's helpful and beneficial to be able to specify some of the most valuable trade secrets so that it reduces the ambiguity. And of course, be sure to train your employees on how to handle sensitive information and consider signed acknowledgements. Next slide, please. During the due diligence phase, there's typically a lot of excitement to get the deal done, but consider phasing in your disclosures. For example, have a broader disclosure of the trade secrets at the beginning, and then as the deal gets closer to closing, consider more detailed disclosures. In the process, limit the access to trade secrets to people who need to know, limit hard copies, consider using a data room, that is a secure room, to share your most valuable trade secrets. Next slide, please. And after the deal, whether or not the deal has been consummated, it's important to monitor the other party for compliance. Consider ongoing verifications with the other party to ensure that no trade secrets or other confidential information is being used. Be vigilant to ensure and follow up that any materials that were provided have been destroyed, and consider having a clear protocol in place in the event of suspected misappropriation. Next slide, please. Just some final thoughts here. Again, much better to be proactive instead of reacting to a potential breach. So a little planning goes a long way. And you just have to keep in mind that trade secrets do not have to be protected with Fort Knox level secrecy. It just has to be reasonable under the circumstances. And a little planning goes a long way. Now I want to turn your attention back to my colleague, Mike Frasinger. Mike, I'm going to kick it off. Yeah, everyone wants to keep trade secrets a trade secret. But when government is involved, there's the additional public interest consideration for transparency. What can a company do to protect trade secrets involving dealings with the government?
Thanks, Tony. We can go ahead one slide. So, yeah, as you mentioned, there's a clear tension in between the desire to keep things secret and the necessity of transparency with regard to public acquisition of goods and services. Obviously, we don't want there to be corruption and cronyism and waste and so on and so forth in government procurement. And so there are additional hoops that companies have to jump through when engaging in that kind of business, and additional risks to their trade secrets that are coming as a result of that. So this is a very complicated topic, and with the amount of time we have, we're really just going to scratch the surface of it. But if there's one thing that you should take away from this section of the presentation, anytime you're trying to get business from the government, whether it's federal or state, or for that matter, foreign, make sure you involve your government contracts lawyer. An in-house lawyer, if you have one at your company, but there are also many firms, including Denton's, with sophisticated government contracting practices that can help clients in this area of business. So what are these transparency rules in US government contracting? These are things like the Federal Freedom of Information Act and what's generally called the state sunshine laws. And they enable, when people are bidding for government business in response to a request for proposal or something of that nature, they enable the competing bidders generally to keep their submissions under wraps until the government decides who's getting the contract. But following the award of the contract, anyone can request access to the bidder responses and proposals. And the purpose of that, of course, is to enable them to have adequate information to bring challenges to the bid awards if something was done unfairly. But what goes along with that is it basically opens up a route for competitors to get access to whatever information it was that you submitted to government. And competitors in many industries do use this to a great extent to gain insights about their projects. So on the next slide, yeah, here we are. Sorry, go, yeah, that was it. Okay, so how do you handle this situation? Well, in general, you, as much as possible, avoid putting trade secrets in the materials you submit to the government. However, that's not always possible. The nature of the request or simply the need to be competitive in what you propose requires you to put in some kind of trade secret. And there are exemptions in, for example, the Freedom of Information Act that protect that kind of information. So exemption 4 of the FOIA prevents trade secrets and commercial or financial information obtained from a person and privileged or confidential from being disclosed to the competitors or other members of the public who request access to the bid materials after the contract is awarded. But these only go so far. Things that are specifically not trade secrets under this rule are your pricing. People want to see how the prices compare for different competitors. Your reference customers and your internal hierarchy and top personnel. Things that do continue to receive trade secret protection in these FOIA requests are generally things like technical specifications and data, software, code, anything like that, that isn't necessary generally to evaluating the fairness of the bidding process. So next slide. The FAR, or the Federal Acquisition Regulation, is the omnibus governing set of regulations for the process of getting business from the government. And it's very long and complicated. It's generally believed that the Trump administration will try to make things somewhat easier for businesses that are contracting with the government, especially at least for ones that are selling what's called commercial items to the government. So not, special work that is done only for the government, development programs, things like that, but things that you can make a case are sold to the general public in some way, and that you're just selling that item to the government, just like a regular laptop computer or something like that. That is generally not going to put you in a situation where you have to disclose any trade secrets to the government. And so people will, of course, try to do everything they can to qualify as a commercial item provider. And so then they avoid the detailed disclosures that may be required for specialized items. Next slide. So by contrast, if you are doing non-commercial or development work, you can't use that commercial item approach, and you are in the situation described earlier where you need to implement precautions under FOIA or the other applicable rules, and make sure that you carefully identify what is being claimed as a trade secret, among other things, and be vigilant with subsequent requests for disclosure that are made by others. So one final point, and then this is again more detailed, but there may be special provisions outside of the FAR that are applicable to the specific kind of work that you're doing for the government. And an example of that is something called protected critical infrastructure information. That's a special NDA that applies to infrastructure like power plants and things like that, that the Department of Homeland Security wants to know about. So be on the lookout for special greater levels of protection that apply to your particular situation.
Thank you very much, Mike. And before we close, we have a few minutes left for Q&A. So I'm going to pose a few questions to our panelists. So let me go, Mike, to you first. Let me ask you first, can you give us one takeaway from your portion about AI and one takeaway from your portion about government regulation?
Sure, absolutely. On AI, it's critical to know the terms of service, terms of use of the various AI tools and use any options that they give you that are applicable to your situation, including up to the highest level of using your own walled off system of AI, if that is appropriate to your sort of business. And on government contracting, as I said, consult with your government contracts attorney because they do this all the time and they will guide you through the processes that are necessary to protect any trade secrets if indeed you have to disclose them in your solicitation for government business.
Great. Tony, let me ask you a question, which is, I know you are very actively involved in many trade secret litigations, but obviously before those cases get to the position of actual in-court litigation, and if a client comes to you and says, I'm concerned about the loss or theft of a trade secret, what can you tell me? What should I do? What's the number one hints or the number one tip I should follow in order to prevent the loss of a trade secret? What would you tell them?
Hopefully there were plans in place before coming to me.
The 3 Ps,
That is, yeah. I think really one of the most important and vital aspects of trade secret litigation is preservation of evidence. In many instances, trade secret cases tend to move quickly. You need to be able to gather forensic data to discover whether or not information has been misappropriated. And oftentimes, in order to prevent your trade secret from being disclosed and used, particularly with a competitor, you have to go to court and seek a temporary restraining order or preliminary injunction. So having processes in place, again, this is the part that I was referring to, being proactive versus being reactive, is probably the most important part in terms of protecting your trade secrets up front.
Great information. Thank you, Tony. Let's go to the next slide. We, on behalf of Denton's and Mike and Tony and myself, we want to thank you for your attendance today. All three of us can be reached at Denton's. We'd be happy to answer any additional questions you may have, and we will be available at your whenever you will need us. So in closing, I want to thank you for participating in today's CLE webinar. To remind you that in about 30 days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps will be required. And as a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. And that's it. And again, if you have any questions or need further assistance, please don't hesitate to reach out. We loved presenting for you today. Have a wonderful day. Thank you very much.